I might have him right here.
Finding with a purge to pay his currently ordered $50 per month for a period of 12 months, that he also be ordered to pay a lump sum of $239.36 for the service fees that were expended to serve him, that he was ordered to pay by the 31st of October that he did not pay. And then separately, there's a motion regarding the establishment of current support. The balances owed are for birthing expenses, but I would defer to Ms. Harmon as to if she wishes a support order to be set or not. We've received conflicting information as time passes. So I would defer to her if she wants a support order, with the understanding that without a substantial change in circumstances, if there is no order, or if an order is set at 0 today, she would have to wait 33 months to readdress.
All right, Ms. Harmon, do you understand everything that's been stated by Corporation Counsel Thomas Schmidt?
Yes, I do.
Are you asking for the court to set and establish a child support order here today?
Not at this time, no.
And so do you understand what was stated by Corporation Counsel, that unless there is a substantial change in circumstances, and that would be substantial, and you may have to wait 33 months in order to have any type of review?
Yes, I understand that.
And you understand that you're waiving any ability, or you're waiving that ability to be able to freely seek child support?
Yes.
Okay, based upon the waiver by Ms. Harmon, Ms. Harmon, have you done this freely, intelligently, and voluntarily?
Yes.
Has anyone made any threats or any harm to you for you to waive your right to get a child support order set here today?
No.
Okay, based upon this, the agreement by Ms. Harmon and waiver of her request to have a child support order set here today to establish that child support order, the court will adopt what has been stated on the record by Corporation Counsel, and will indicate that no child support order will be in effect other than what was stated by Corporation Counsel on the record. The court will find that Mr. Johnson is in default for his failure to appear here today. He was here on October 2nd, 2025, in which he was placed under record, or placed under oath, and provided testimony to the court. And this additional date was set in order to proceed with regards to child support and any past child support or other birthing expenses that have been accumulated. Anything further, Ms. Thomas Schmidt?
Just that the contempt order be for a period of 1 year.
The court does find him in contempt, or it has been done by commissioner, and it will be in place for the period of 1 year.
Start date on
November 1st. Anything further on this matter, Ms. Thomas Schmidt?
No, Your Honor, thank you.
Thank you. I do have to ask now you sit back so I can proceed with Mr. English, and then we will get right back to child support. Thank you very much. And Mr. Reed?
Yes, Your Honor.
I fully and 100% appreciate your heads up about today. Thank you. And Ms. Bauer, thank you for making sure that we are in victims' rights compliance.
Yes.
Did Mr. Felisky have to leave?
He did, Your Honor. He said he's making his way in.
Okay, that's fine. He's making his way in here.
Yes, Your Honor.
I can wait if we need to wait, we can wait.
I think we can proceed. He may come in during the hearing, but that's okay, Your Honor.
Okay, we will go on the record in the matter 25 CF 44, State of Wisconsin versus Robert English. The state appears through District Attorney Kevin Schmidt in person. We have sorry, I heard a cell phone. If we have cell phones going up, please mute them. We have Mr. Ryan Reed, defense counsel in person, Joel Feliski, defense counsel in person, and Robert English appears in person in custody. We're set here today in this matter for a final pre-trial. It's my understanding I have received a plea questionnaire waiver of rights form with jury instructions, et cetera. So it's my understanding that the parties have reached some type of agreement. Is that correct, Mr. Reed?
Yes, Your Honor.
Can you please recite the agreement for the record?
I would defer to the state to set that on the record, Your Honor.
Mr. Schmidt, can you please recite the agreement on the record?
Mr. English will be entering a plea to 5 counts of burglary. There'll be a joint agreement of 3 and
5 counts?
yes.
Okay. It just says 1, so I'll just put 5 on there if you're okay with that. Times 5. All right. 5 counts of burglary. Okay.
The joint agreement is all 5 of those will run concurrent to one another, but consecutive to the sentencing after revocation we did previously. If there's a joint agreement of 3
Can
and
you
3.
just speak a little slower?
Sorry,
Thank you.
still out of breath from running up and down the stairs. There's a joint agreement of 3 in, 3 out, concurrent on all those, consecutive to the sentencing after revocation, and a joint agreement to the restitution.
And what is the restitution?
Let me see if I can find that.
Joint and several and
Joint and several with
actorlings.
Stephanie Achterling and Kenneth Achterling.
Okay.
Let me find the number. It's on the restitution supplement that we sent to the court, though.
Joint and several to co-defendants if and only if they are found guilty at a trial.
Yes.
Or if they reach some other type of agreement.
Take me just a minute to find the restitution supplement again, because there are a lot of documents in this case.
I can see if I can pull it up too.
I believe the total amount is $32,344.84.
Okay. So, Mr. English, you stipulate here today to the amount of, you said, I have $32,344.84. That's what it is?
What was that?
$32,344.84.
Yes.
Mr. English, by entering a plea here today, are you indicating to the court that you stipulate and agree to joint and several responsibility for the amount of restitution of $32,344.84 to any co-defendant that is either found guilty in trial or reaches some other type of agreement with the state where they are guilty?
Yes,
All right, thank you. So you are pleading guilty to 5 counts of burglary, is that correct?
yes,
And the agreement, as I understand it, is that there will be a recommendation to the court for 3 years of initial confinement and 3 years of extended supervision to run concurrent together with all 5 counts, but consecutive to your other matter, which is a revocation sentence, correct?
yes,
And that's correctly stated.
Yes.
Okay. So I have in front of me a plea questionnaire waiver of rights form. Do you recognize this document?
yes,
Did you go over this document thoroughly with your attorneys?
yes, we did.
Did they essentially go over it word for word?
Yes, they did.
And you understand everything completely?
Yes,
If there was something on this document you did not understand, did you ask one or both of your attorneys to explain it until you did?
yes,
So you're telling the court you fully understand everything contained on this document?
yes, ma'am.
And is this your signature on the second page?
Yes,
Again, you're pleading guilty to 5 counts of felony burglary. Is that correct?
yes,
And you are 40 years old, 12 years of schooling. You can read, write, you understand the English language. Is that correct?
yes,
I have also accompanying this document, jury instructions for what the state would need to prove your guilt beyond a reasonable doubt. Did your attorneys go over this with you?
yes,
And you understand this completely?
yes,
You also, it also contains the maximum possible penalties that you face for each of these charges. Did your attorney go over that with you?
yes,
And you understand that completely?
yes,
is this intended to be a simple plea and set sentencing at another date? Or are we intending to move forward for a sentencing too, knowing that we have a lot of victims and it appears I have one victim who is appearing by video.
I was informed just a plea today.
Okay, so just a plea and set sentencing for another date?
I
That
don't,
would,
I don't need a PSI because we just did the sentencing after Rev, but I thought it was just gonna be a plea there because I thought the court was gonna ask for a PSI, so maybe I assumed incorrectly.
I haven't thought, I didn't know that there was for sure an agreement, and what the agreement was, but we'll see, and we will set sentencing for another date, whether or not there's a PSI. Okay? Does that work?
yes, Your Honor.
Okay. All right, so you are not receiving treatment for mental illness or disorder, no drugs, alcohol, or other medications.
No.
Because you're being charged with crimes, you are entitled to constitutional rights, and each of those rights is listed on this document. Do you understand all of those rights?
Yes,
And your attorney went through them with you completely?
yes, yes, they did.
Do you need me to go over those rights with you in any more detail?
No,
And you're telling me for certain you understand them?
yes,
Do you understand that once you plead guilty to these charges, you're waiving and giving up those rights?
yes,
Do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes,
Do you understand that you're pleading guilty to felonies? As such, you will no longer be able to use or possess a firearm for life.
yes,
No longer able to vote in any election until your civil rights are restored.
yes,
Do you also understand that with regards to this matter, there are certain charges that are being asked to be dismissed and read in for purposes of sentencing? Do you understand what that means?
yes,
Do you understand you're not going to be found guilty of those charges? However, the court can use those charges in its sentencing discretion, but may not sentence you beyond the maximum possible penalty for each of those charges. Do you understand that?
yes,
Okay. Now, with regards to these matters and the burglary charges, the state would have to prove. This is going to take a little bit because I was not prepared for a plea, but just give me 1 second. The state would have to prove. Wait. Trying to pull up the charges that are yours. As to count 37, building of a burglary of a building or dwelling as a party to a crime on or around Thursday, January 11th, 2024, in Burnett County, Wisconsin, as a party to a crime, you intentionally entered a dwelling or a building owned by PA without the consent of that person in lawful possession of the place and with intent to steal items of value. Do you understand what the state would need to prove?
yes,
And for the record, you are looking at that criminal complaint or information, correct?
yes,
All right. And do you understand the maximum possible penalty of this Class F felony could be a fine of up to $25,000 or imprisonment of up to 12.5 years or both? Do you understand that?
yes,
With regards to count 40, burglary of a building or a dwelling, party to, do you understand what it means to be a party to a crime?
yes,
Do you want me to go over that legal definition with you on the record?
no,
You fully understand what that means?
yes,
Okay. Then as to count 40, burglary of a building or dwelling as a party to a crime. It alleges on or around Wednesday, March 6, 2024, in Burnett County, Wisconsin, as a party to a crime, you intentionally entered a dwelling or a building owned by GJ without the consent of the person in lawful possession of the place and with intent to steal items of value. Do you understand what the state would have to prove?
yes,
Do you understand the maximum possible penalties could be a fine of up to $25,000 or 12.5 years of incarceration or both?
yes,
Do you also understand what it means to be a party to a crime?
yes, ma'am.
As to count 43, burglary of a building or a dwelling, party to a crime. Do you understand the state would have to prove on or around Friday, September 1st, 2023, in Burnett County, Wisconsin, as a party to a crime, you intentionally entered the dwelling or building owned by FG Trust without the consent of that person or entity in lawful possession of that place with the intent to steal items of value. Do you understand what the state would have to prove?
Yes,
Do you understand what it means to be a party to a crime?
yes,
Do you understand that upon conviction, you face a fine of up to $25,000 or imprisonment of not more than 12 and a half years or both?
yes,
As to count 46, burglary of a building or dwelling, party to a crime. Do you understand that the state would have to prove on or around Thursday, March 7th, 2024, in Burnett County, Wisconsin, as a party to a crime, you intentionally entered a building or a dwelling owned by MM without the consent of a person in lawful possession of the place and with intent to steal items of value? Do you understand what the state would have to prove?
yes,
And again, do you understand what it means to be a party to a crime?
yes,
Do you understand that upon conviction, you face a fine of up to $25,000 or imprisonment of up to 12 and a half years or both?
yes,
I believe I went over all of those burglaries, correct?
Yes, Your Honor.
All right, thank you. Now, do you understand, Mr. English, there is a recommendation, a joint agreement that would recommend to the court a sentence of 3 years of initial confinement and 3 years of extended supervision, all to be concurrent with each other within this case, but consecutive to your other conviction. Do you understand that I'm not bound to follow that recommendation?
yes,
Said differently, if I thought the facts of the case were egregious or that it warranted it based upon these facts and or based upon other information in your criminal history, character, etc., I could sentence you all the way to the maximum possible penalty, and I could sentence you to the maximum possible penalty for each of these charges. Do you understand that?
yes,
And it could be concurrent or consecutive. Do you understand that?
yes,
Do you still wish to proceed and enter guilty pleas?
yes,
Did you go over this very lengthy 38-page criminal complaint with your attorneys?
yes,
And in particular, did you go over the section called the probable cause section that basically says what happened throughout those dates and times and why you were charged with these crimes?
yes,
For the most part, are those facts accurate?
yes,
Are you admitting here today that you in fact did engage in conduct and acts that constitute the legal definition of a burglary of a building or a dwelling as a party to a crime on these 5 occasions?
yes,
Are you admitting here today that you are guilty of burglary of a building or a dwelling, at least as a party to a crime for these 5 conducts and incidents?
yes,
So you're pleading guilty because you're guilty of these charges.
yes,
Mr. Reed and or Mr. Feliski, may the court use the probable cause section with the statements made by your client here today to find a factual basis.
No objection, Your Honor.
Has anyone made any threats or any promises to you, Mr. English, for you to plead guilty to these charges?
no,
You're doing so freely and intelligently, telling the court you fully understand what you're doing
yes,
and voluntarily.
yes,
Has your attorneys represented you competently?
yes,
Have they answered all of your questions?
yes, they have,
Have they looked at this matter thoroughly?
yes, they have,
Have they looked at all of the voluminous evidence in this case, the discovery, and discussed it with you?
yes,
And you've discussed your side of these cases with your attorneys?
yes, I have,
And you've discussed any potential alibis or defenses that you think you have?
yes,
Have your attorneys discussed with you any potential defenses they think you may have in these cases?
yeah,
Have they discussed with you a potential of a lack of defenses in these cases?
yes, they have,
And they've went over these matters with you thoroughly. Is that
Yes.
correct? Are you satisfied with your attorney's services?
yes,
Do you have any questions for the court or for your attorneys before we proceed?
no, I don't,
Mr. Reed, as counsel for Mr. English, do you believe he's entering these pleas competently?
Yes, Your Honor.
Do you believe he understands the maximum possible penalties for each of these charges?
Yes, Your Honor.
Do you believe he understands the role of the court and the discretion the court has?
Yes, Your Honor.
Do you believe he understands the facts as alleged in this case with these charges, along with what the state would need to prove?
Yes, Your Honor.
Do you believe he understands both the strengths and the weaknesses of each of these charges within this case?
I do, Your Honor.
Do you believe he understands the constitutional rights that he is giving up here today?
Yes, Your Honor.
Do you believe he's entering pleas today freely, intelligently, and voluntarily?
Yes, Your Honor.
Is there anything you would like to state on the record as it relates to this matter and your client?
Thank you, Your Honor. I believe both Attorney Flisky and I have worked with Mr. English to explain the matter. I think he understands what he's doing. In general, understands what's going on, Your Honor, and I think he is prepared to move forward.
All right. And you thoroughly went over the evidence, the discovery, and any issues brought up by Mr. English?
Yes, Your Honor.
And you fully researched and looked into any potential alibis and or defenses that he may have brought to both of your attention?
Yes, Your Honor. I think that we've met with him, spoken with him about the case, potential witnesses, potential defenses. He's had multiple opportunities to speak with us. And I believe that he's been able to do that, Your Honor.
Thank you. And Mr. English, do you believe in the discussions with both of your attorneys that you have together reached a strategic decision as to why you are entering pleas here today?
Yes,
Okay, thank you. And if I didn't state it before, do you understand that if you're not a citizen of the United States, your plea could result in your deportation?
yes, you have.
And you're pleading guilty to felonies, no use or
Yep.
possession of firearms?
Yes, you
Okay,
have.
I just want to make sure I've covered the
Hey,
things.
you're going through it very thoroughly.
Check, 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 check.
Yep.
I don't like appeals.
No.
All right. Do you have any questions for the court or for your attorneys before I proceed? This is your time.
No.
Take as much time as you need if you have any other questions.
I'd just like to say I'm sorry for my actions. That's all.
I appreciate that, and you're going to get a bigger opportunity to state that at the sentencing, okay? All right. Then, based upon that, we are going to go through the 5 counts. And I am not going to list the number because I don't recall it off the top of my head, and I would have to go boom, boom, boom again, but there are 5 burglary counts.
Yep.
As to the first burglary, building of a dwelling, a building or a dwelling as a party to a crime, how do you wish to plead?
Guilty.
As to the second count of burglary, building or a dwelling as a party to a crime, how do you wish to
Guilty.
plead? As to the third
Yeah.
count of burglary, building or a dwelling as a party to a crime, how do you wish to plead?
Guilty.
As to the fourth count of burglary, building or a dwelling as a party to a crime, how do you wish to plead?
Guilty.
As to the fifth and final count of burglary, building or a dwelling as a party to a crime, how do you wish to plead?
Guilty.
The court will find your pleas of guilt are done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your pleas of guilt. Based on that, I will find you guilty of those 5 counts. The remaining counts against you and you alone will be dismissed and read in for purposes of sentencing. A judgment of conviction will be entered today. I don't believe I need a PSI. I don't think there's any, but if you think Mr. Reed or Mr. Flisky that it may be beneficial to the court, I am willing to order one. That's
If I may, Your Honor. I would agree with the court. I don't believe a PSI is necessary in this matter. I would not object to the scheduling of a sentencing hearing to allow for victim rights compliance or the ability for victims to be present.
okay. Ms. Bauer,
Yes, sir.
how many victims and length do you think I may have?
I would say,
And they may appear by video conferencing to provide their statements.
I would say 3 for sure, but possibly 8.
There are 8 total, just 3 we know from talking to would want to give
Okay.
a statement.
The earliest I would be able to get you in, and I'm going over another sentencing I have for an all day. I don't believe it's going to be all day. I think the most it would be is a half day. Would be December 16th at 1.
I unfortunately have a hearing at that time in Sawyer County, Your Honor.
Is it something you can move?
Likely, Your Honor.
Because I want to make sure that if Mr. English would like to get this matter resolved on a more quicker fashion, then it's something that you can look at moving. If not, this is between you, Mr. Reed, and Mr. English, whether or not your presence is necessary.
I should be able to move that time, Your Honor.
Okay, does that work?
What day did you say?
December 16th at 1.
Are we shortening Winquist's sentencing hearing?
I just stated, I don't believe that'll take all day. I
Okay.
think at most it'll take half of the day. I just booked it for all day because I wasn't sure.
That works for me then.
That 1 o'clock would work, Your Honor.
All right, we'll see you at 1 o'clock, December 16th, 1 o'clock, December 16th, okay? Yes.
Before we break, I think the reason why Judge and I don't need a PSI is we just had a sentencing after revocation packet.
And
Does
you
Mr.
can-
English's attorneys have access to that?
I was gonna say, you can have access. If you don't have access, we can make sure that you get a copy of that so you have all of the information.
Thank you, Your Honor.
Yes, Your Honor. Thank you.
Thank you. Nothing further than we are adjourned. Thank you.
Thank you, Your Honor. Sometime next week.
Or Mr. Smith, don't leave. Or if you are looking at ordering the transcript for that, please let Ms. Jeske know as quickly as practically possible and she can get that to you.
Yes, Your Honor.
Okay, thank you.